Hello, hello. We are here to protect your business. In Arizona, there are actually in the whole United States, but our focus is in Arizona. There's a lot of small businesses that are just out there hustling and making a difference. When they get to the size where they have about usually at least 5 employees and they're doing around 1 million or more in gross revenue, it starts to look like something that can be valuable on its own. And if you're the owner and you're there or doing more than that, and you're still grinding away and hustling to make it work, or you're starting to see your business operate by itself some, you're wondering what happens if something happens to me. And if something happens to you, that's where it gets scary because do you really have a plan in place or is it just set up for absolute chaos when an emergency happens? So, welcome to today's webinar on how to transfer an operating business without chaos, an Arizona owner's guide to protecting your legacy and your family. These are webinars we do all the time, and I welcome you to it. If you're looking for other topics, I invite you to go to keystonelawfirm.com/events, and you can register for those right there. If you're looking for past topics, you can go to our YouTube channel and see the recordings of those at youtube.com/Keystone Law Firm. Before I jump into the content, we got to do the legal notices. So this is not legal advice for anybody's specific situation, even though this is stuff we know how to do and we're happy to share our information and give you all the best tips we can think of. Don't take action based on what you learn here today, okay? Every single family we sit down with, even though we have our toolkit and, we always work from the toolkit, every single family has a little bit of differences that can make a big difference for you. So don't do something based on this. This is just educational information of a general nature. All right. So the real question for a small business owner is if you don't show up on Monday because of some emergency, who takes the wheel on Tuesday? What happens? Do you know what's going to happen? Do you already have that in place? So what I'm going to give you today, what I hope you walk away with is at least a couple nuggets of something new. You go, oh, I didn't know that. I that's great. I can do something with these 1 or 2 new nuggets that I got. And that's phenomenal. My second goal for anybody who sees this webinar is if you get all this material and you get to the end of this and you think, oh my gosh, I need to do something about this, that you get a chance to see how we work at Keystone. And you get a chance for a taste of what we do, how we do it, and what some of the tools are that we might use, and gives you a chance to say, you know what, they seem like somebody that I might want to work with, and you can at least investigate us if it seems like a good fit. Because I don't want anybody who needs this help to not know where to go. So this is going to be hopefully a good place for you to get to know us. But look, if that's not you, that's perfectly fine. I refer you to my first goal that you walk away with a couple nuggets and you're thinking, I got some good information out of this. So we'll be here for about 30 minutes, 45 minutes, something like that. And I hope you walk away with 1 or 2 of those goals. When I work with a lot of business owners, I have a lot of business owner friends, and just like a lot of things, it's easy to think, I got my business is my plan, like it's there. I already know who's going to take over. We've already talked about it, and it's all set up in my head, but without the actual legal structure in place, the actual tax structure in place, the actual operational documents in place, it becomes a big liability for an owner to pass away, to have a medical emergency. And it all of a sudden becomes a big liability. We've had multiple times where we get called in after somebody has passed away unexpectedly, and there's a business and it's operating, and it's just it's chaos. Nobody knows who's really in charge. The operations manager or the COO might know what to do to kind of keep things going, but really those decisions that have always been made by the owner, they're not there anymore. So who makes those decisions? Is there anybody to make those decisions? So that's what I want to give you, are these tools, because the reality is about 70% of businesses fail when the founder is gone. And that's a pretty consistent statistic. And you look at decade over decade, and it's really frustrating to see that. You grow a business, you work your butt off to grow a business, and something happens, and 70%, right? 3 out of 4 times, it doesn't make that transition. All the employees just kind of float away, disappear, go find other jobs. All your customers move to other businesses. And then your family's left with kind of a shell that is the liability that has to be cleaned up somehow. That's a lot of business failures. And it doesn't have to be that way. It can be an asset that's passed on to keep going. So the first big thing I want to talk about is this procrastination trap. It's easy to be overwhelmed by a lot of this stuff. We talk a lot about this because there's a lot to think about, and it can feel overwhelming. There can feel like there's too much. Like, how am I going to eat this elephant? There's too many things to think about. I'm already overwhelmed running my business day to day. The first step in any business owner's plan is to think about your own personal estate plan and how the business can fit into that, so that at least you have the first step done. That's a big and important step. Your own personal estate plan as a business owner is always the first step for us, because it says who is going to be in charge of your whole estate, which your business is part of that. And at least then we've got your best thinking, the best person you think who might be able to at least run that business, maybe, or they're the best person who might know who to appoint to be in charge of those big decisions for the business. The reality is, when something happens to a founder, to an owner, and you don't have this plan in place, you don't have your basic estate plan in place. We're talking about wills, revocable living trust, power of attorney, these basic documents. There's a forced takeover. It gets triggered if there's a sudden illness. It could be a stroke, any kind of medical emergency. It could be something like Alzheimer's, though usually that's a slower illness. And so there's hopefully time to get things in place if that's diagnosed. But that trigger is going to force things into Arizona's default laws. And that's where the probate court is going to take over. And the probate court is going to say, is there somebody designated in any legal documents to do this job, to manage the business, and honestly, to manage all your financial affairs? And if there's nobody designated, if you don't have those legal documents in place, the court is going to have to appoint someone. And who's the best person for that? Is it really who the court is going to appoint? I don't know. Usually, it's whoever steps up. It's whoever comes forward in your family. And if you don't have somebody in your family who comes forward, you don't know what's going to happen. It might be a judge who gets to just pick a completely unrelated professional who doesn't know your business, who doesn't know your heirs, your loved ones at all. And what are they going to do? How are they going to run the business? How are they going to direct those big decisions that need to happen? Oftentimes when a founder or owner is still working in the business, there's probably daily or weekly pretty big decisions you're making that keep the business moving forward and moving in the right direction. And if you don't have somebody who knows your business, what are they going to do? What decisions are they going to make? They're probably going to figure out how to wind it down just to minimize the liability, the exposure to your financial life to your estate. And if your business has been a significant source of income to you, to your family, to your partners, is that really what's best? It's probably going to cause a big loss in financial income and in financial resources. In Arizona, without your basic estate plan in place, if there's a medical emergency, you're looking at what's called a conservatorship to designate someone for your equity ownership to manage that part of your estate. And that conservator is going to have to report to the court. They're going to have to justify decisions. They might have to post a bond for the value of your business. They might have to get the business appraised. All of these things are expensive. In a conservatorship, you're looking at 2 to 3 attorneys that are going to be required by the court to operate the conservatorship correctly. And all of those are getting paid out of your pocket. That's expensive. You're looking at $300, $400, $500, $600 an hour for 3 lawyers to do all the legal work that's required in these conservatorship matters. Talk about slow decision making. And if your business is going to be affected by slow decision making, that's going to hurt even more. After somebody passes away, then you're looking at typical probate. And it's not easy to operate a ongoing business through probate because there are timelines and deadlines and all kinds of other things that have to happen. Somebody is going to be required to report to all the beneficiaries, here's what's happening. If any of them object, it's going to slow down decisions again. And I've run one business for almost 20 years, a second business for almost 3 years now. Slow decision making in any business is really bad. It's honestly something that can kill a business. And so these default systems that take over in a emergency are a big problem for a business owner. So this is really the first thing we recommend you do is get your personal estate plan in place with wills, trusts, power of attorney, and all the healthcare directives, all the things that you would think about protecting your regular estate plan, but specifically having sections in there that address here's the business part of that estate plan. You address maybe who's going to be operationally in control of the business, maybe who the business is going to go to when you pass away, things like that in your regular estate plan. That's always step 1 in this process. Step 2 is thinking about how the business is going to be distributed when you pass away. A lot of business owners, their business is the largest asset in their estate when they pass. It's the thing that has the most value. It's the thing that was producing income. And there's a lot of families who are, whether they're business owners or not, they think, oh, I'm just going to leave it to my spouse and then to my kids equally. Well, if your spouse is not involved in day-to-day operations, understandably, you still want the value to go to them, but are they going to know who to designate to keep the business operations going? Make sure they do. But then after that, that's what this secret number 2 is really all about, is leaving it to your kids. Saying I want my estate to go to my kids equally is perfectly fine if all you have is cash and real estate and maybe investments and mutual funds and bonds and stocks and things like that. But when you have a business and you say I want it to just go to everybody equally, you're looking at your heirs, or your heirs are looking at that from very different perspectives, because oftentimes one of the heirs is maybe one who's been working in the business and they've been helping you and maybe being groomed to grow up in as far as in management or taking over the business. And they're definitely looking at the business very differently than the heir who is not, who's just looking at the business as another chunk of inheritance. The problem with this, back up a second, is the one who's actively involved. What do they want? They want to grow the business. They want to keep this thing going. It's their It's their future. It's their long-term financial security. They want control over it. They want to grow it. They want to reinvest. Well, the heirs who are not involved in the business, what do they want? They want profit. They want distributions. They want cash out of the business and put in their pocket. They are at direct odds with each other, aren't they? They truly are. This is a big point of contention to think about. You might think, oh, everybody's amicable. They all get along. They all get along until the business shows a profit on paper of a few $100,000, a couple $1,000,000. And one of them says, the one in operation says, hey, if we take this, we can invest and grow and blah, blah, blah. And the other one goes, no, I want a distribution. Give me my money. Especially if they're 50-50 owners, or if you have three, one of them's in operations, the other two are not. Guess what? The other two might be able to outvote the one. That can cause some real big disagreements and really hard feelings between those heirs who otherwise did get along really well. So what you want to look at and think about is there a way within your whole estate, the whole estate, your business, your primary home, other savings, investments, maybe life insurance that you have, look at all of those assets and figure out, how can I equalize what they get, even if it's not from the same bucket? Okay. So that's what you look at. You look at, can I get them all equivalent value, even if the business goes to one child and the other one or the other two or the other three, they share in the equivalent value of cash, real estate, securities, life insurance, other things like that, so that the one who's in there grinding away day to day to day to day can continue to take the business and make those investments, operate it how they want to operate it, personally invest their time, their sweat in growing it, and that growth is to their benefit. It's obviously future growth, but to their benefit. This does require that the business be appraised, right? Because you need to know what the value is. And it might require some type of a buyout from the other kids. If the appraised value is $1 million, but the whole estate is only worth 1.5 million, well, there's not enough other value to give to the other kids. So they may have to buy some portion out from the other kids, but that's a good thing to include as an option in the whole business structure, is a buyout for the one who's operating it. And then that can just be some type of a secured promissory note that they are going to pay off the other heirs over time. And obviously that's usually paid off with cash flow from operations of the business, so that they're not pulling money out of their own pocket. But you want to look at, how can you equalize the assets between them of your whole estate, rather than saying everybody gets a third of the business or everyone gets half of the business, because then you end up with this big conflict between the ones who are operating and the ones who are not. So that's a second secret to think about. The third one to think about is the tax situation. A lot of businesses that have been in operations for many decades and are doing really well were originally set up as C Corps. And because that's just what was done traditionally. It's a traditional classification. It's one that's been around the longest, and not a lot of people set it up that way and have reevaluated that decision to see if that's still the best thing going forward. And so it's just been going as a C Corp for a long time. The challenge with a C Corp is the double tax that happens when there's a transfer. Okay? When there's a transfer to new owners. That's the big trap here. Okay? If you know about C Corps, there's taxation at the corporation level. And then when the corporation distributes profit to the owners, there's now individual taxation on those distributions, right? And that individual taxation is going to be taxed at the individual tax rates for those distributions of profit or dividends. And they're also going to be stuck with that net investment income tax. So there's that double taxation there. And that can eat away a ton at that retirement bucket, either for the surviving spouse or for the heirs. And so a lot of clients want to think about this and say, hey, maybe we should not be a C Corp anymore, and we should convert to something that's taxed differently, because now there's more options. It's been, they've been around for a while, but it might be worth thinking about that, because when you combine these as the tax rate, you're looking at such a big tax bill. You might want to think about converting to an S Corp to avoid that. So an S Corp is something that does not get taxed at the entity level. It avoids that extra corporate tax at the corporation tax, and it just passes through all of the tax to the individual. So you still file an S Corp tax return, but no taxes due. And then the individual tax return, that's where it reports the income or loss from the business, and then it's taxed on the individual level. Converting to an S Corp can help save a lot of those taxes during the transfer, when you ultimately do transfer to your heirs or your spouse. But the trick is you can't do it at the last minute, right? You can't say, okay, now I'm ready to transfer this. Here we go. We're transferring it and the transfer is done. Or unexpectedly, the business owner passes away and now we're going to transfer it. Let's convert it to an S Corp and transfer it to avoid that extra taxation. You can't do that. The IRS tax code says that the conversion has to be done at least 5 years before the transfer. 5 years. Otherwise, if it's done anytime within that window and then you make a transfer, the IRS unwinds the S Corp election and you end up under the C Corp tax rules anyway. So to take advantage of these S Corp tax saving strategies, you really have to plan ahead. You have to start the process way before you think you're ever going to do this, way before there's ever an emergency. This is just, talk about planning ahead. You've got to do this 5 years or more before this trigger happens. Okay. The other thing is that we see a lot with taxes is clients want to transfer their business down to their heirs. Their business, might be worth a few $1 million in all reality on the open market, but their child doesn't have that much money to buy it from them. So they want to sell it to them for a little bit of a discount, And if you do that, the IRS has what are very specific technical rules for family transfers. And they can actually take what you said was the purchase price between you and somebody who's within that category, and they can reclassify the whole thing. They will force your business to be appraised on actual fair market value, and then that's where they will peg the value. And then they will set the taxes at that number, not the number you agreed on with your child. So don't come up with creative little family discounts and pretend like that's going to pass muster, even if it's completely documented by an agreement and all these things. The only way you can justify that is if you have a third-party independent appraisal by a qualified business appraisal that establishes the value. That's how your transaction needs to be proven and ready for an audit. The sticker shock of what happens with that if you do one of these family discounts and then the IRS recalculates the value is that now there's going to be a whole bunch more taxes due. And where's that money coming from? Where's that money coming from? What you want to do, if that's the case, if your business is worth, say, $5 million, but you want to sell it to a family member for $2 million, is you want to strategically use your lifetime gift exemption to make up that difference. Okay. The difference between those two numbers needs to be documented as a gift. And maybe you strategically use that against your lifetime exemption. Maybe you use some of that as your annual gift exclusion. There are different ways to make up for that so that it can pass an audit and it won't trigger a bunch of extra taxes on your surviving spouse or your child after you pass. It is documenting it. It is by making sure you've got the right pieces in place to pass that audit. Okay. The fourth secret that I want to cover is the unintentional partner. Not all small businesses have partners in it, but a lot of them do. And you and a friend got together years ago, and you said, "Hey, let's try to start this thing," and you did, and you're 50-50, and it's great, and you've been operating it and growing it, and both making good money. Awesome, great. The last piece of this puzzle is, what if something happens to your partner? Okay, we started at this by saying, what happens if something happens to you? But what happens if something happens to your partner? What happens if your partner has a medical emergency? Who's your new partner going to be? What if they pass away unexpectedly? Who's going to be your business partner? Is it going to be, what if your partner goes through a divorce? Is your partner's ex-wife or ex-husband or soon-to-be ex's divorce attorney going to be coming in trying to help you run the business? Yeah, they are. If your partner doesn't have an estate plan in place, like we talked about with power of attorney and a trust and a will, all saying who will take over, then who is going to take over? Some random, fiduciary companies, local judge in a conservatorship? Are they going to become basically your equity partner and try to tell you how you want to run the business? It's going to be messy, and your partner is going to end up with all kinds of, again, we talked about the lawyers that have to be involved in those kinds of cases, the expenses, the costs, the slowdown on decisions. Those kinds of things, they just cause all kinds of gridlock, because now you're in partnership with some complete outsider who doesn't know anything about how you guys run the business and all the decisions you've made. A lot of them informally, they haven't been documented in the minutes. They've just, you guys talk and you make a decision and go. You talk, you make a decision and go. You talk, you make it, and now it's no longer going to be like that. And very often, that new partner, they're going to be wanting all kinds of cash, right? They're going to want to maximize their distribution. Since they're not working in the business day to day, they don't feel any moral obligation to let the money stay in there and be reinvested. They're like, I'm passive here. I just want cash out. And that's going to hold the business back from growing. So obviously, your partner needs their own estate plan. But something else really critical is to have a buy-sell agreement between you two, right? And that's just, buy-sell agreement, very simply, is while you both, or if there's 3 or 4 or 5 of you, while you are all alive and well, it's not the operating agreement, it's not the shareholder agreement. It's a separate document, and it's a contract that says, if something happens to one of us, we all agree that here's what's going to happen. You might say, in the event of my disability, in the event of my death, in the event of my divorce, those are the 3 Ds we typically plan for. My equity, whatever it was, half, a third, whatever it was, my equity immediately is offered for sale to the remaining owners at market price. You might agree on how that is calculated, or a method for calculating what that market price is. But in that agreement, it's immediately offered to the other owners for purchase, that first right of refusal. And what that does is it makes sure that operational control stays with those who are operating the business and know how to operate it. Now, obviously, the remaining owners, how are they going to buy it out? How are they going to come up with the cash to pay that person's estate or that person's power of attorney or their trust or whatever it is, right? If there's an immediate first right of refusal, there has to be the ability to purchase it from them. So again, oftentimes that comes in the form of a secured promissory note, and that comes out of the cash flow from operations. It can oftentimes come from a SBA loan. SBA loans on those kinds of things for a business that has history of revenue and profit. SBA can loan on that, and then that purchase price is paid to the disabled or the deceased or the one who's going through a divorce to give them a chunk of cash, and then the shares go back to the other owners, and now it's done. They got their equity, and now you stay in operations. Buy-sell agreement is very powerful to help keep any of those emergencies or those really messy things like a divorce from impacting and destroying the operations of the business. Very simple to set up, and should be set up whenever there's more than one owner. Those are the 4 big things that we see. So just a quick chaos check. Are your corporate minutes, do you have them? Are they blank? Are they outdated? Have you documented those big decisions? You want to make sure you have. That can help going forward if there are any of these emergencies. And then, just think about it. Does your cash register stop when you stop as the owner? Are you critical to that? Is it mission critical that you're there every day? If it is, you got to think about that and put things in place so that it can keep going. And then just operations. Does it hurt if ownership changes? Are you the one with all the knowledge, all the institutional historical knowledge about how you do things and how things are done, and all the custom relationships you have with each of your customers? Are those all in your head, or can somebody pick them up and run with it? Do they have those documents in place to know what to do next? So that's just a quick chaos check. You want to think about that stack of what you need for a smooth transition. You create a quick blueprint. This is just a high level. Here are the things that to do in an emergency. This person's in charge. Here's where these contracts are. Here's how these things work, right? There's a whole blueprint. You go through and fill that out, and then have some internal governing instructions. Transition of authority from owner who was doing all these things. In event of emergency, this job goes to this person. This job goes to this person. This job goes to this person. Final operational decisions is this person. Have those internal governance instructions in place. And those are legal documents. Those are legal documents that you're going to have, you're going to create. Buy-sell is one. There's lots of others that you might need just depending on the business. And then come up with an asset equalization framework for the equity that you own in the business. If you're a 50% owner of a business and you want your 50% to go to your spouse, should you pass, you want to make sure it goes that way. But then if it goes to your kids equally, you want to think about it. Does it really make sense for all of them to share the business equally, and the one who's operating it, or the 2 out of 3, or the 2 out of 5 who are in operations, for them to have to get shareholder agreement and votes on their operational decisions, right? Because they're likely going to be the ones that want to continue to invest and grow the business, and come up with a way, instead of spreading the business out, of allocating the business to the operational heirs and other assets of equal value to those who aren't in operations. That way everybody understands you wanted everybody to get equal shares, but it doesn't have to be equal parts. And that's all I had today. I'm super quick. Today was quick. This was a good overview for those of you who have a small business in Arizona and single owner, multiple owners, and you've got sort of 5 or more employees, you're doing more than $1 million in revenue. These businesses are the ones that have the possibility of being passed on and continue to be grown by those in your family that might be interested in continuing it. I wanted to mention that if this is you and you're thinking, geez, I really should be thinking about this, then I want to invite you to schedule a quick 15-minute call with me. And I'll have Alexis post that link in the chat. And I'll just jump on with you anytime that works to do a quick business protection call. There's no cost for that. And I'll just say, hey, what's going on? Tell me about your business real quick. See if it's something we can help with. And if it is, tell you some next steps. If it's not, I'll give you a couple ideas of things you might want to think about, maybe put in place, and tell you any information I can. No catch on that. Just love to get on a call with you. So click that link. It's in the chat right now, and we'll jump on a call and get right to it. Thanks for coming. That's all I had today. We appreciate being able to share this information. If you do want to watch this again, it'll be up on YouTube in the next week or two. Have a great day, everyone. Thanks for coming.